Hi, everyone. Thank you for joining us today and welcome back to the Bulletin podcast. I'm your host, Charina Garcia, and I'm here with WR's Director of Visa Consulting, Charlie Oppenheim, to recap the July Visa Bulletin and what it means for the HR, immigration, and global mobility folks listening in on a Spotify or watching us on YouTube today. This is our monthly HR Q&A episode, and it's relatively quick listen. We are including timestamps in the description, so if you're listening on Spotify or watching on YouTube, you can skip ahead to hear our responses to specific questions. So before we dive in today, a couple of housekeeping items to run through. First, we do a special HR Q&A episode of the Bulletin podcast every month. And the link to submit questions is in the show notes or the description of the video, depending on where you're consuming this. So please submit your questions and Charlie and I will answer them in an upcoming episode. Second, we'd love to hear any feedback or suggestions that listeners have on the podcast. So please share that in the comments or reach out to us directly. We also hope that you consider subscribing and following the podcast on Spotify or WR Immigration on YouTube. Okay, let's dive into the questions. So here's our first question. Can you speak more about the recent change in final action dates and the potential for EB3s to go unavailable? Charlie.
Sure. The final action dates, the State Department appears to have decided to make their major advancements in the final action dates on a quarterly basis, that being in October, January, April, and potentially again in July, in an attempt to maximize number use. And for third preference, for rest of world third preference, the final action date has retrogressed. For the month of June, it was November 22nd of 2022. That date has been retrogressed to December 1st of 2021. That action is states' attempt to control number use under the overall annual limit. They have indicated in the July bulletin that it is possible that date may retrogress once again for August or September, or potentially become unavailable. In a best-case scenario, no further retrogression would occur.
And a lot of people are asking, because of that nice, pleasant surprise, about how they said that it was probably going to retrogress for the EB2, but then it actually advanced. What are your thoughts on why that possibly happened?
It's a little concerning that in June they said that the final action date was going to retrogress for the month of July in order to control number use. And then a month later, they advanced the date by over 2 months. That kind of calls into question the statistical data they're being provided on which they make the determination of the dates. But it is a very, as you say, a very positive thing to have occurred for the employment second preference applicants. And I would suggest that anybody that is within that July date to file as quickly as possible.
Okay. And then the question number 2, which kind of was similar to question number 1, what could have prompted USCIS to move the bulletin by 2 months? I know of some people who were forced to move out of the U.S. because they ran out of status. I'm not sure if this contributed to such, because many will have to put up with consulate's backlog in addition to the bulletin's backlog. How far do you see the dates moving this upcoming fiscal year?
I don't think anybody if you mentioned potentially leaving the country, I do not think that would have had any impact on the decisions, because that information would not have been available within a 1-month period. So that action will not have any effect. I think that the retrogression in the third preference, again, that has been occurred in order to control number of use this year. For the month of October, hopefully there will be a recovery from that retrogression, if not in October, within the ensuing months, because the State Department and USCIS realize that such a retrogression has a dramatic negative impact on applicants, and they would try to mitigate that problem as quickly as possible.
Yeah, and I think this question brings up another point of people who had designated their I-140s for adjustment of status, but then they run out of time and they have to consular process. And so typically, if you've already told the USCIS you plan to file adjustment of status and you change your mind because of circumstances, you actually need to file a Form I-824 to notify the USCIS to forward your file to the Department of State. And then once the Department of State receives it, that's when the National Visa Center will start gathering all the documents. The problem is that with the I-824, it can take anywhere from 6 months to a year for the USCIS to forward that file. So what ends up happening is that by the time the Department of State gets to your file, right, the date probably is still current, right, Charlie? Because,
Right.
8 months, 9 months, 10 months would have already passed before you get scheduled for an interview.
Yeah. And once the case gets to the National Visa Center, it can be another, 3 to 4 months before they receive and process all the required documentation, at which time they potentially could schedule you for interview. So it is a potentially long, drawn-out process, as you described.
Yeah. And then another question here, what impact might the 2024 election have on the visa bulletin in 2025?
I don't think that would have any impact on the dates. The dates for fiscal 2025 are based strictly on the annual limits. The annual limit in the family sponsored categories will be 226,000. The fiscal 2025 employment-based limit will be a minimum of 140,000 plus any unused family-sponsored numbers from fiscal 2024. So the election will have absolutely no impact on those annual limits.
So over the course of the 20 years that you were with the Department of State, did you ever see the election have any impact on the visa bulletin?
No, because as I said, the dates are spelled out in the Immigration and Nationality Act, how the determination is made, basically as I just described. The only impact, a presidential election would have if that resulted in Congress then doing some type of action. But the last time there was any major immigration reform was the Immigration Act of 1990, which took effect in fiscal year 1992. And there's been many, many elections since that time.
Okay, and any final thoughts to share today?
No, again, as the retrogression of the rest of world third preference date and the rapid advancement of the India employment first preference, which was last available at this point in July of last year, it underscores the importance of applicants filing in a very timely manner once their priority date has been reached by the final action or application filing date.
Okay, thanks, Charlie, and everyone who tuned in today. See you next time.